Hey everyone, Kaosy Umeh here, aka Attorney Nodal. So, you guys, today I'm here to speak to you about custody and exactly what the court looks at when determining who should get custody. So, when it comes down to it, boilerplate, what all courts look at is what is in the best interest of the children or the child. So, in Maryland, this happens in a divorce case, in a regular custody case, in a modification case. The first thing the court must start with is what's in. And to do this, Maryland has two cases they look at. And the first case is Taylor versus Taylor, and the second case is Montgomery versus Sanders. So Taylor versus Taylor and Montgomery versus Sanders gives us the factors the courts use to determine the best interest of a child. And we have tried to sum it up in Maryland in a Maryland rule that other people can look at instead of having to read the whole case. And that rule is Maryland Rule 9-204, Part C. I'm sorry, I have to look that up because I don't keep that in my brain. But Taylor versus Taylor, Montgomery versus Sanders, just about every divorce attorney will know this, and just about every custody attorney will know this. So I'm just going to go over a few of the factors. Mind you, this is not a comprehensive list of all the factors. These are just a few that are mainly focused on. And I'm actually getting them from the Maryland People's Law Library. There are other factors that the courts will also consider that I'm not going to go over. And remember, all these factors come in case by case. Some of them, the ones I'm going over today, are like the general ones, but the other factors that are listed in 9-204, those are other factors the court could look at, and those are going to be case by case. Okay, so let's start with the number one factor. The number one factor the court looks at is the primary caregiver. Who's going to be who has been the primary caregiver of these children? And that basically means who made them breakfast every morning, who made them dinner every night, who packed their lunches for school, who found the daycare they attend, who found the school they attend, who takes them to their extracurricular activities, who takes them to the doctors. Things of that nature helps courts determine who has been the primary caregiver. The next we look at is fitness. And this looks at both your physical and psychological fitness. I once had a case when the opposing party she was bipolar, so she had several instances or several episodes over their marriage. My client was able to get custody there but and I like clients like this. He really did not want to exclude mother from the children's lives, but he was even willing to agree to overnight custody or overnight access with mother, and he let mother pick the dates she would prefer this. And he was also willing to, if she ever had an episode during one of her visitations, wherever she was, all she had to do was call him, and he wouldn't come back to court to use that against her in the future. So that was a really great case. It was just they no longer could make it work as husband and wife, but they were both willing to do whatever it is they needed to make sure that both parties were active in the children's lives. And we had to finagle custody and access back and forth. And it wasn't because we were arguing; it was because we were trying to somehow factor in her bipolarism and how that would affect custody and put in I'm sorry, put in some sort of language in there that would cover some of the episodes she might experience to make sure that there was a way that the kids would be safe during this period. So anyway, that's one aspect of fitness the courts could look into. They can also look into your physical fitness, and that's really that could do. Well, it rarely has to do with weight, but I guess it could be. I suppose if you had a 3-year-old child and one party weighs 600 pounds and the other party weighs 200 pounds, that could factor into a custody situation because clearly one party would be more likely to be able to run around and pick up after a toddler versus the other party who will have some more mobility issues. So I can see that being an issue in a custody case when it comes to weight, but it has to be something that extreme when it comes to weight. But also, there's also age. If you have a party, let's say one party is 70 something years old and they're first time parents, versus another party who's in their early 20s or late 20s or early 30s, and they are parents. The courts will also have to make, well, look into those discrepancies in ages when determining custody. But again, it has to be something that wide. Like, there has to be such a wide gap between the age or the physical fitness of the parties for the courts to really go, okay, yes, this is going to be an issue. The next is the character and reputation of both parties. And really, for that, what I usually do is bring in friends and family members to testify as to how they've witnessed you parent your kids, and also as to what your character and reputation is in the community. Typically, that isn't a problem. I suppose it could be if you have one party who's a known liar or no thief, or I don't know, if they just generally have a bad reputation amongst their community, and that can be just the local mom group or the local dad group or the neighbors or whatever it is. But I typically don't run into that issue. Um, Also, the court looks at if there are any previous agreements between the two of you. So, when this happens often, people will separate, and while they're separated, they come into some sort of agreement as to what to do about the kids while they wait for the divorce. The court really relies on those in making a decision. It's not determinative. The court must not follow that plan you guys have made and followed, but it is something they look at, and again, it's not determinative, but it is very important because you're asking the court, if you are asking the court to change that agreement, there has to be a good reason why. Next is the ability to maintain family relationships. So this comes into when you have cases where you have half brothers and sisters or step brothers and sisters, and also when you have extended family members that are very active. I once had a case every year they go to Georgia for a family reunion. And the family reunion was on the mother's side, which was my client. And the kids were now, at the time we were in court, the kids were 13, 11, and 9. No, 13, 11, and 7, sorry. They were 13, 11, and 7. But throughout their lives, especially that 13-year-old, for 13 years, she has gone to Georgia every summer for a family reunion. And after the family reunion, they spend 2 weeks in the country. The parents go back, but they leave the kids there with the grandparents. It's hard, like, who's going to maintain this relationship in the future when you guys get divorced? The court has to consider that. Because, yes, father's family, father's family was involved, but they weren't as involved as mother's family was in the child's life. So the court really does have to consider these things. And also, when you have like step brothers and sisters or half brothers and sisters, the courts do not want you guys to lose. They don't want the kids to lose that relationship simply because their parents are getting divorced. Um, then next is the child preference. So this really only comes into play the older the child gets. So child preferences, I always recommend that the child be at least 11 for it to become a serious factor in the case, because very few judges allow a 6-year-old to testify or a 7-year-old to testify. They're just considered to be way too young. So, yeah, I usually recommend between 11, once you hit 11, that's when I feel like the court can take the child's testimony a little more seriously. And of course, this testimony rarely, if ever, happen in open courts. They usually happen behind the scenes in chambers with the judge alone. And the judge will ask them a few questions. And usually, judges will allow the attorneys to give a list of questions they would like the judge to ask. Um, Keep in mind, there are a few cases where the judge will allow a 6-year-old or 8-year-old to testify in open court. But the only time I've ever heard of this happening was during a domestic violence case where a father had been ridiculously abusive. And that wasn't even in circuit court, that was in the district court. This was before the divorce case was filed. The judge in that case allowed the minor children to come to court and testify in open court about what father did to them. So it rarely ever happens, but that doesn't mean it never happens. The next would be material opportunity. Obviously, that is money. Who makes more money? Uh, but that doesn't come in play as often as you think it would or how you think it would. Um, I've had cases where one party makes in the mid triple digits and the other party is maybe 50, 60,000. But that is not determinative of who gets custody. It really isn't. I know people worry about that a lot, but it really isn't determinative. What will determine whether or not that party who's making that 60 or 50,000 gets custody or gets primary physical custody, and that's what I'm talking about here, people. Primary physical. I'm talking about physical custody here. Um, but what will determine whether or not that 50, $60,000 parent gets custody of this child isn't going to be, oh, they make significantly less than the other party. It's going to be, what are you doing with that 60, 50,000? Do you have a do you have enough space for the children? Do you have enough time for the children? Are you devoted to these children? In my case, the client had two children, a boy and a girl. They had a one bedroom apartment. So what mother did is that mother slept in the living room, the kids slept in the bedroom. And to give the kids privacy, because again, boy and a girl, the boy was 7 years old, the girl was 12 years old. So at that point, the girl was getting to the age where she needed a little bit more privacy. So what mother did was she bought she bought a little divider set to put in the middle of the room, just so that daughter would have a little more privacy. And she was able, and people have talents. I have no decorating talent, but she had talents. So she was able to divide the room in a way that it really looked like the daughter was in her own little separate bubble room. I could never do that, but she clearly put in the time and effort into doing that for her child and to make sure that both children were comfortable sharing this room. Because you look at the pictures and it's hard to believe that they were actually sharing just one room. But that is something the court took into consideration. Okay, this is a woman who doesn't make as much as the other party, but she's made sure she put her children first. She is sleeping in the living room. Her children are sleeping comfortably in this nice room. And the room looks like it was, again, I have no talent for this, but this woman had talent. And she made it look like it was two different bedrooms when it was just one. So that was something the court really took into consideration. And she ended up with primary custody. So just because you have more money doesn't necessarily mean you're going to win. She had been the primary caregiver. Father had gone away for a while. He had been missing for over a year. He came back and he wanted custody. Money does not always mean winning when it comes to custody situations, because again, the main issue here is what is in the best interest of the children. And then what else? So we have the courts will also consider the age, health, and gender of the children. So age comes into play, especially for like younger kids, especially when you have cases where you have like a 6 month old, 8 month old, a 2 year old. Age is really important, especially I would say for that 6 month old, because the courts, excuse me, because 6 months olds are probably still breastfeeding, and it's hard to convince the courts to allow a breastfeeding child away from mother. Mind you, I also had a case where the 2 year old was still breastfeeding. The courts were more than willing to go, nope, overnight custody. I mean, 50-50 custody is appropriate here. This child, the 2 years old, could be away from mother. The court did not tell the mother she couldn't keep breastfeeding, but they told mother if this is really a concern and she only wants her child on breast milk, pump and give the milk to father. If not, father can buy formula or get regular food for the child. So age does matter. For a 6 month old or 5 month old who's still breastfeeding, the courts will take that into consideration when determining custody. But obviously, the older you get, the less of an impact age has. And once you hit age 16 in Maryland, a child could actually make a request to the courts for their own custody determination. So age matters. And also if we're talking about older teenagers, a 16-year-old, a 17-year-old, it's really hard for a court to enforce any custody orders on a 16-year-old or 17-year-old, because the only option the parent who has to enforce this custody agreement or custody order has, well, the only option that parent has is if this child doesn't want to go, are you asking the mother to get in a fight with her daughter to force her into a car and drive her to the father, or to get in a fight with her 16-year-old son and force that 16-year-old into the car and drive them over to the father? And what if the child was driving and the child just doesn't want to go? What then? So the younger they are, the more interest the courts have in the age, and the older they are, the more interest the courts have, because they realize at the very young age it might not be appropriate to separate um, the baby from the mother. And at a very old, and an older age, not very older, and the older age is very hard to enforce custody. So keep that in mind when you're in court for custody. What else? The courts also look to see if there have been any periods of surrender. Like I mentioned in my other case, father left the house for over a year and then came back later to request custody. So when I say he left the house, he moved to a different state and he rarely called the kids and he rarely visited because he really was far away. But the court does have to look at that. Father chose to move out the house. Father chose to move over 6 hours away. And father chose not to make phone calls regularly after he did all this. So that's something the courts will consider. Have you surrendered your child? Have you abandoned this child? I've never had a case of I take that back. I have had cases of just plain abandonment, but those don't tend to be contested cases. I've never had a contested case where somebody is opposing from the other side, where there has been an issue of abandonment. But I've had lots of uncontested cases when one party has just left. The next, the court looks at religious issues. This is typically not an issue in my cases because I found that most people tend to be of the same religion when they're having a child together, especially when they're married. But if they're not, I found that there is one party who's always willing to give more when it comes to when it comes to religion. They don't care so much about religion, and they're willing to acquiesce the other party's request for whatever religious practice they want. But if they're not, the courts will look at the past history of the children and whether or not and what the children have been doing in order to determine whether or not to grant one person's religious request over the other. What else? Oh, disability. The last one I'm going to touch on is disability. So, disability of the parents is only an issue if we can prove that this disability will actually affect custody. I've never really had that come out, but I have come up. I mean, but I have had cases about when you have the child themselves is disabled. And in my case, I'm thinking about an autistic child. The court has to consider who's going to be more responsible, what's going to be better for this child when this child is autistic. And obviously, the other factors I spoke of previously will help the court determine how this disability, how this autism should be treated in the case of this custody determination, and what would be in the best interest of the child. But okay, so that was it. I just wanted to make sure you guys understand when it comes to custody, it's really all about what is best for this child. It's not about the past relationship between you and your spouse or between you and your ex. It's all about the child. How will this affect the child? What has the past done to the child? How you two treated the child? What the other party has done to you or what you've done to the other party is only relevant if it somehow affected the child and you can prove it affected the child. So, yeah, that was pretty much it about custody. I know this video ran a little bit long, but this is a topic that can go a lot longer. So, I am trying to make this short. Let me know if you have any questions. Feel free to leave a comment and please don't forget to like and subscribe. Um, Again, if you have any comments or if you have any topics you want me to cover, just let me know below. And if not, I'll see you guys later. Have a great day. Ciao.